The next case to come before the court this morning is State of Ohio versus Mark Blackburn. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve any time, let me know when you get started. I'm keeping track of the clock this morning to let you know when you're reaching into that rebuttal time. You will note before we get started on this case, you see 2 judges, 3 are hearing the case.
I'm sorry, Your Honor, my hearing is atrocious. Could you say that again?
You see 2 judges sitting up here, but 3 are actually hearing the case. The judge that could not be in physical attendance today will be reviewing the video tape. Please don't use the names of any victims or minors. Keep your voice up and remain behind the podium. We've read the briefs. You're ready to proceed when you are. Would you like to reserve any time for rebuttal?
Your Honor, I'd ask you to reserve 5 minutes.
Certainly.
Thank you, Your Honor. May it please the Court, good morning, Your Honor. We have filed a appeal on this matter in sentencing. Your Honor, we believe that the Court has lost its way in regards to this consecutive sentencing and to the prison sentence, Your Honor. A review of the record does show that there's clear and convincing evidence against consecutive sentencing. One of the requirements of consecutive sentencing is that the trier of fact find that there is a high probability that the defendant will reoffend, that there's a possibility that he's a danger to the community going forward. A review of the record shows that Mr. Blackburn has taken significant steps to mitigate and completely eliminate any possibility of him reoffending. Furthermore, Your Honor, a review of his criminal record and PSI indicates that Mr. Blackburn has the lowest possibility of reoffending, a lower score of 3, indicating that he would not likely reoffend. Your Honor, he is, in all ways, he has been apologetic. He has shown remorse in this matter, and we don't believe that the record shows that Mr. Blackburn was in any possibility likely to reoffend on that. We believe that the Court lost its way in that regard, Your Honor. In addition, Your Honor, we believe that a review of the record shows that the trial record does not support the judge having adequately and properly taken into account the sentencing factors before entering a sentence on this matter. A review of light cases shows that her sentence in this matter was unusually heavy. Mr. Blackburn was sentenced to the almost max on both charges, and then she ran consecutive. When the record before the court, including the trial transcripts, the pre-sentence investigation, the testimonies of victims, and family show that this is not the most serious of the version of this offense. Even if you take into consideration the original underlying charges, which a trial court is allowed to do. So we believe, Your Honor, that the imposition of a prison sanction on this was inappropriate. We believe that the prison sentence here was unduly heavy for the level of the offense and the level of damage that Mr. Blackburn is alleged to have, or has been convicted for. The standard in regards to the consecutive sentencing is that the court is to review this with deference to the sentencing court, and then review the record if the court finds by clear and convincing evidence that the sentencing court did not appropriately sentence on this matter, then it is to amend, change, alter that.
It looks like the court did, according to the prosecutor's brief, make those findings explicitly on the record.
It did make those findings on the record, but those findings are not supported by the record itself. It almost seems like the judge checked off what she had to check off to make those findings, but the facts in the record don't support those findings. There's nothing in the record that would suggest that Mr. Blackburn was prowling or going to reoffend or has committed other crimes of any sort. It's just, it almost seems like a boilerplate checkoff. And given the fact that that is a requirement in the statute before a judge can make that finding, one can understand that these Ohio legislators intended that judges review these facts and apply these facts to the record. It's not just something that's to be assumed. There has to be something there, a meat on the bone, so to say, that backs up that finding. The state cites Bynum. I believe that Bynum actually is a great example of proper application of the facts to the sentence. In Bynum, the defendant had, on multiple occasions, for over the course of a year, committed repeated offenses against the individual who was in his care. When he was found out, it was found out that he had made death threats against that individual. It was clear by the reading in Bynum that the defendant in Bynum was an active, proactive threat to not only the community, but also to the victim in Bynum. In this matter, there is nothing on the record to suggest that Blackburn was a threat to the victim in this case. There's nothing on the record to suggest that.
What about the fact that there are multiple charges here?
There are two charges here.
Involving multiple incidences.
There are two charges here, and it's unclear based on the pre-sentence investigation and the statements made on the record when in time about these two incidents happened. It's alleged maybe 5, but possibly 2. It's not really clear in the record whether or not this was something that happened repeatedly, all at once, one day. It's not really made clear. And I believe that the prosecutor has the burden to show that to the state that wants to make that argument. The judge cannot just assume this happened multiple times over a period of time. And there's nothing in the record to suggest that it was. It could have been easily twice in one night. It's not really clear. What is clear, though, is that Mr. Blackburn did make efforts to make sure this never happens again. And given Mr. Blackburn's age, the fact that he has been put on a sex offenders registry, and I think the PSI said he had 5 speeding tickets total in his criminal history. Stable family lifestyle, it doesn't seem like he's somebody who we're going to see in the courthouse again. And this matter was pending for, according to the record, 4 years. During that 4-year period, Mr. Blackburn had no violations. He was never late to court. He complied with all the court orders, so it doesn't seem like there's any reason to believe that he would go out there and violate a court order in that regard. Thank you.
Thank you, counsel. You'll have your full 5 minutes for rebuttal.
Morning, Your Honors. May it please the Court, Lindsay Poprocki of Lorain County Prosecutor's Office for the State. The State submits that the trial court's imposition of a prison sanction and consecutive sentences in this matter was proper and should be affirmed. Mark Blackburn's main contention on appeal is that the imposition of consecutive sentences was not supported by the record. In doing so, he argues that ordering consecutive services of his sentences is disproportionate to the seriousness of his offenses, and according to Blackburn, the record does not support the conclusion that the harm he caused to the victim was unusually great for a crime of a sexual nature, or that he posed any serious danger to the public. He relies largely on the PSI and notes that his risk of reoffending was categorized as low and that he had no significant criminal record. Here, Blackburn pled guilty to an amended indictment whereby the state dismissed 2 counts of kidnapping and amended 2 counts of rape to sexual batteries in violation of RC 2907.03A5, felonies of the 3rd degree. At the time of the plea, the state indicated that there would be no merger of the charges and that there was no agreement as to sentencing. After the plea was accepted, the trial court ordered the PSI. And just generally, a review of the PSI revealed details of the sexual incidents, which there were several, to indicate that an 11-year-old victim had disclosed being raped by Blackburn, who she considered kind of like a grandpa. The victim detailed her fear during the incidents and her feelings of disgust and uncleanliness ever since the incidents. At sentencing, the trial court heard from the victim's parents in victim impact statements, since the victim herself was uncomfortable speaking. The victim's mother expressed how her daughter was only 11 years old when she was put under Blackburn's care, and that instead of protecting her, Blackburn used his power to take advantage of her. The victim's father spoke of the negative physical and emotional impact that Blackburn's conduct had on her and the overall toll that these incidents had taken on their family. Both of the victim's parents advocated for lengthy prison terms. The state reiterated that request and requested that consecutive prison terms be imposed. After hearing from defense counsel and Blackburn, who did apologize for his actions, the trial court sentenced Blackburn to 2 4-year prison terms and ordered them to run consecutively for a total of 8 years in prison. The trial court stated its findings to support its imposition of consecutive sentences on the record and reiterated them in its sentencing entry. Now, contrary to Blackburn's assertions, the record supports the consecutive sentencing findings. The trial court indicated that in fashioning its sentence, it had considered not only the PSI, but the victim impact statements and the sentencing factors. The record demonstrated that Blackburn, a stepfather figure, sexually assaulted and took advantage of the victim, an 11-year-old girl, while she was under his care on more than one occasion. Because of Blackburn's conduct, the victim suffers from serious psychological and physical distress, and that includes extreme anxiety and eating disorders. In its brief, the state did cite to State v. Bynum, a 3rd district case, where 54-month consecutive sentences were ordered after the appellant pled to an amended indictment on 2 counts of sexual battery. In that case, the appellant engaged in frequent sexual conduct with a minor who was at that time no more than 13, or who was between 13 and 14 years old, and the appellant was her legal guardian. Much like the victim here, the abuse in that case was discovered after the victim's mother read her diary. In this case, the abuse was discovered after the victim dropped a note at her middle school. In finding that the record supported the consecutive sentencing findings, the 3rd district noted several factors. There, the record demonstrated that the appellant engaged in a sexual relationship with a girl who was no older than 14 years old. The victim was not a relative stranger to the appellant. She was his ward. Because of the appellant's actions, the victim suffered severe and lasting psychological harm. Although Blackburn would argue that this case is different, several of those same factors appear in the record here. Ultimately, the record supports the findings that consecutive sentences are necessary to punish Blackburn. The second assignment of error is that the trial court should not have imposed a prison sanction, and the state submits that this argument is precluded from review because Blackburn only asked this court to reassess his sentence for compliance with statutory sentencing factors under 29.29.11 and 29.29.12, but this court, relying on Ohio Supreme Court precedent in State v. Jones, has held that it does not have the authority to, as part of its appellate powers, to reweigh those factors. And that this court expressly held that in State v. Knight, where the appellant challenged his sentence merely on the basis that the record did not support the sentence because the trial court failed to properly consider the statutory sentencing factors. Blackburn's challenge to his sentence is no different, and for those reasons, the state respectfully requests that this court affirm Blackburn's judgment. or the trial court's judgment and sentence in this matter.
Thank you, Counsel.
Thank you, Your Honors.
Your Honors, in regards to Bynum, it is our contention that it does not apply, or it more supports the defense's argument, or Mr. Blackburn's argument over the state's, specifically that Mr. Bynum was an active threat and was going to be a threat to this child going forward, which is why the court there saw consecutive sentences being appropriate for Mr. Bynum, including the fact that Mr. Bynum had threatened a child with a gun. There's no evidence here suggesting that Mr. Blackburn threatened the child. There's no evidence here that Mr. Blackburn had made any indications of any danger to anybody. In fact, his entire criminal history is devoid of anything but speeding tickets. Even the factors in this case don't seem to show any sense of violence or any sense of ill will towards another human being, beyond the fact that this is a child that Mr. Blackburn is using for sexual purposes, sexual gratification. The Ohio legislature has reviewed these kinds of cases. The Ohio legislature has determined that sexual battery in this matter has maximum possible penalty for the worst instances of those offenses, 5 years. The Ohio legislature has said that consecutive sentences is only appropriate when it can be demonstrated that it is necessary to protect the public from future offenses by the defendant. There is nothing in this record that suggests that Mr. Blackburn will reoffend. There's nothing here beyond Mr. Blackburn's interactions with this child of criminal conduct. And that those interactions have been eliminated. There's a protection order in place, there's registration requirements in place. Mr. Blackburn is not likely to reoffend here. And furthermore, it doesn't seem that the court even considered whether or not Mr. Blackburn is going to likely reoffend, because there is no conversation in that regard. The PSI puts in there that these are the facts that occurred according to the victim. It's a little murky. There's a review in that PSI which indicates that Mr. Blackburn is not likely to reoffend. The state doesn't argue it in their sentencing argument. The victims don't argue it. The parents of the victims don't argue it. In fact, the only arguments that go towards whether or not Mr. Blackburn would reoffend are the arguments by his counsel, and his counsel indicates that Mr. Blackburn has taken extensive steps to prevent himself from reoffending. In addition, he has shown remorse, he has shown responsibility, he's not somebody who's taken this lightly. In cases where consecutive sentences have been imposed, defendants are either shown to be belligerent, objectionable, not willing to take responsibility for that matter, or likely to reoffend. A number of the consecutive sentencing cases, the defendant has a lengthy criminal record of different things. Mr. Blackburn has a couple speeding tickets. I think I have more speeding tickets than Mr. Blackburn, Your Honor. In that regard, we believe that the court did not properly consider the sentencing factors. We don't believe the court properly entered in and made the appropriate findings under 29.914. Your Honor, we believe that these factors are mandatory, that these factors do not exist in the case, in the record, then the court cannot give Mr. Blackburn consecutive sentences no matter how much it wants to. We believe that this may be, of course, a case of just the judge losing her way in that regard. But we find that the record is completely void of the necessary requirements to make consecutive sentence findings beyond the checkbox. An entry saying that I did the thing that I have to say I did, as opposed to actually having those factors present in the case. And given that that is a requirement by the Ohio State Legislature, it has to be something there in the record, meat on the bone, saying that Mr. Blackburn is a risk to the public for future criminal conduct. And we just don't believe that is anywhere in the record, Your Honor. Furthermore, a review of this case in any sense shows that the sentencing factors were not applied It is clear here that Mr. Blackburn has been sentenced based on what appears to be a factor, not an appropriate weighing of all factors in this matter. Thank you, Your Honor.
Thank you, counsel. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which we mail to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Thank you.